Hey there, Legal Tea listeners. This is your host, Jenny Roselle. Today's episode of Legal Tea is a cautionary tale, a real-life case with real-life clients with real-life facts, though, of course, their names are altered for confidentiality purposes. And what are we talking about today, you ask? Well, we're going to be chatting about something that I don't think a lot of people know, or maybe they just haven't really connected the dots, I'm not sure. In my little estate and elder law world, we of course help married couples and unmarried couples, significant others, all the time, right? Sometimes couples come in and think there is such a thing as like a joint last will and testament. That's not a thing, at least here in Indiana. That is not a thing. I actually don't know of a specific state that even has such a thing, but I digress. So when you do a last will and testament, you do it for yourself. Like your name is at the top of the document. Last will and testament of Jennifer L. Roselle, for example. While a lot of married couples, their wills say the same thing, like everything to each other first, then everything to XYZ beneficiaries, you still each have a will referencing each other, then those XYZ beneficiaries after each other. Well, that's fine and dandy, right? Except, did you know that upon the first death of you and your spouse, the surviving spouse can actually just create a new will and change who those XYZ beneficiaries are? So think about this. Lately here on Legal Tea, we've been talking a lot, kind of ironic. I'm not really sure why we're on this topic so much lately, but we've been talking a lot about blended families. So let's just, keep talking about them, right? Shall we? So say you and your spouse are a blended family, as in each of you have kids, but not with each other. Maybe you get this wonderful idea to do some estate planning, and you end up saying, okay, we're going to leave everything to each other, and then we'll leave everything equally to all the kids. Then, say you pass away. Your spouse could get a new will and yank out your kids. Crazy, right? Well, on today's cautionary tale, a very similar thing happened to our clients. So let's name them Ralph and Sarah. So Ralph had no children, but had a dear, dear niece. Sarah, on the other hand, had a child. So when we met with Ralph and Sarah to do some estate planning, we started getting to chatting about who is getting what and how much and where as in as in who's going to serve as executor and healthcare representative and power of attorney. And finally, we get to the $1 million question of, okay, who's going to be the beneficiary or beneficiaries? And that conversation got a little heated. Ralph wanted his niece and Sarah's son as equal beneficiaries. But Sarah did not want Ralph's niece listed as a beneficiary in her will. I think ultimately Sarah sort of gave up and said, heck with it. So Ralph and Sarah, they did their wills, and Ralph's niece and Sarah's son get placed as the beneficiaries after Ralph and Sarah both passed away, of course. So fast forward some time, and it was not long actually at all, like maybe 6 months or so after they signed these wills. And my office gets a call from Sarah, totally frantic. Ralph unexpectedly had passed away, completely unexpectedly. It was 2 days that she called after, 2 days after Ralph had passed away that Sarah had called our office. I think he passed away on a Saturday and she called on Monday. And our normal office protocol after someone passes away is to schedule a call with a paralegal that helps families in these sort of after death administration cases. So Sarah called on Monday, and we got that phone call set up with the paralegal for the following day, Tuesday. So if you're keeping track, we're a mere 3 days after Ralph passed away. Most of the time, this call with the paralegal really involves more logistics, like, okay, where are the assets? How are they titled? How much? What can you pay? How can you pay? Etc. So that was not the case for Sarah's call. The paralegal hops on the phone call with Sarah, and instead of really talking about what needs to be done following Ralph's passing, she kicks things off by talking about what changes she wants to make to her will. AKA, she wants to cut out Ralph's niece. And I always write and type out these episodes, because otherwise I would be scared I'd accidentally say the client's real name, or maybe I just blab about who knows what for who knows long. But anyway, even saying it now still kind of blows my mind. Okay, so I suppose people, grieve, react, and cope in different ways. So perhaps Sarah staying in sort of business mode is just how she grieved and coped. In her defense, I see a lot of clients do this following the death of a loved one. They just don't pop up their head to grieve. And I mean, truly grieve. Instead, they keep their head down and stick to business. I'm sure that's a psychological experiment has been done on why people do this or when, but that's not what we're talking about here today. So Sarah had this phone call with the paralegal, and the paralegal, of course, lets us know what Sarah wants and needs. Prior to Ralph's passing, Ralph and Sarah had primarily worked with my husband, Justin, who is an attorney here at my office as well, in case you have missed prior episodes of me mentioning that. So the paralegal got Sarah scheduled on Justin's calendar to sign her new will taking out Ralph's niece. And this reminds me so much of something, and it's something I've talked about on Legal Tea before. Your estate plan is your estate plan. It's no one else's estate plan. So you know what? If that's what Sarah wanted to do it to it, my friend. Just because someone else doesn't think it's maybe morally right to do, I just did air quotations and you can't even see me doing them, morally right. That doesn't matter. It's Sarah's plan. And I'm sure Ralph is above shaking his little index finger at me. Or maybe he knew that if he passed away before Sarah would absolutely do what she did. Maybe he knew that. So maybe he isn't waving his little index finger at me. Let me be loud and clear for you all. There are estate planning options that would have definitely prevented this. So yes, you can create an estate plan to prevent this very thing from happening. Unfortunately, it just requires more planning than maybe you really super want to do. And it definitely requires more than just a last will and testament. So yes, Ralph and Sarah could have done more planning, but more planning comes with a touch more expense, legal fee-wise. And they just didn't want to spend the money. Well, the result of that decision is that Ralph's niece is not going to get anything when Sarah passes away. So let's talk about how you can do this. How is kind of a better way to do things instead of just trusting and hoping that your spouse will take care, not change the will. To achieve this in the most economic fashion and cleanest fashion, really, that would involve a trust. And what happens when you have a living trust, whether it's revocable or irrevocable, is you actually take your assets and place them in the name of the trust. So say, for example, my husband and I have a trust, and we take our house that is owned by Justin and Jenny, and we put the house in the name of Justin and Jenny as trustees of whatever we name our trust. So let's call our trust the Old Trusty Trust. So our house is in the name of the Old Trusty Trust. It's not in Jenny and Justin's names. It's in our Old Trusty Trust name. We can move our checking and savings into the Old Trusty Trust, life insurance into the Old Trusty Trust, investments into the Old Trusty Trust. Super long story short, we own very little in our personal names. Our trust owns it all. So when one of us passes away, the trust is what dictates sort of what happens and when. So one way to accomplish protection against your spouse changing things up after you pass away is to actually have a trust that turns irrevocable upon the first passing, upon the first death. If it's carefully crafted, if the trust is carefully crafted, it can be set up in a way that allows someone, it could be the spouse, but it doesn't have to be the spouse either. It could allow someone to make changes to the trust should the law change. And the trust needs to be amended due to XYZ change in law. Though that person cannot change the substantive provisions, like who gets what and how much provisions. That would certainly protect the beneficiaries from getting cut out, huh? You know how I mentioned earlier that doing this through a living trust is the most economic fashion, or the most economic option? Well, I'm sure you're thinking, what? A little insider secret. Trusts are always more expensive, legal fee wise, than just doing wills, like a last will and testament. They not only provide a ton of benefits compared to a will, but they're also much more work because we have to get your assets transferred into the name of the trust. Well, you could do all this I've been talking about through a will, where at the first passing, assets pass through the will, and the will creates a trust inside of it. So those are called testamentary trusts. But to have those testamentary trusts govern assets, those assets would have to go through probate, meaning they'd have to be individually owned and not beneficiary designated. So those assets would have to go through a probate court proceeding. And probate has a reputation. You know, a lot of professionals, to be honest, will try to make it sound like it's like your worst nightmare come true. It's usually not scary. It's nothing like you see on Judge Judy. Most of the time, it's just more a little annoying. It takes a while. It's a public process. So I'm looking at you, nosy neighbors. And it's kind of costly. And it's costly because of the legal fees. So if we wanted to do just a last will and testament and put those testamentary trusts inside of it to gain protection for beneficiaries getting cut out, we've got the cost of the will, right? But then we've got the cost of probate later. And 99.99999% of the time, doing a will and having to probate it later will be more expensive than doing a living trust from the get-go and avoiding probate. So this probably does not come as a surprise to you. If it does, I don't know what rock you've been living under, but money on the table changes people. Perhaps it's because I do this estate stuff for a living, so I'm just super used to talking about this kind of stuff. But I think it's a very fair conversation to bring up to your spouse, especially if you have just a will and are part of a blended family. Or even if you're not part of a blended family, but you and your spouse have different opinions on who should inherit how much. You know, I've met plenty of clients, plenty of times that, you know, dad thinks Johnny is a bozo and a half, and mom thinks Johnny is a gold star child. Would dad reduce bozo Johnny's share if mom passed before him? Maybe. Maybe not. But could he? 100% yes, unless there's some solid estate planning in place. Something I'll mention as I wind up this episode is while I'm a licensed attorney in Indiana, I belong to a wonderful national organization called Lawyers with Purpose, whose members are all estate and elder law attorneys like me. So if you are a Legalty listener outside of Indiana, and one of my episodes has inspired you to do some estate planning, and you want a trusted referral from me in your respective state, just reach out. You can email me directly to legaltpodcast@gmail.com, and it comes straight to my phone. So easy peasy, just shoot me a message. I'm really good about replies. Alrighty, next week's topic is a current event, a current trend. So something I've seen or run across that I think would be interesting to chat about on here. During next week's episode, we're going to be talking about another wild guardianship case. You remember how several months ago, that's kind of cool to say that I've been doing this for several months. But anyways, so several months ago, we talked about Britney Spears. Well, hey, she's free now, by the way, if somehow, again, you're still living under the rock and don't know that she's free of the guardianship. So thanks to that new attorney of hers that stepped in named Matthew Rosengart, that's how she kind of got free of the guardianship. Well, Matthew has started helping someone else get out of a guardianship, kind of a icky guardianship situation. So tune in for that next time. Until then, Legalty listeners, be well.